patent business since 1970 when I joined the patent office as an examiner. And I've been with Oblon since 1975. I've seen a lot of changes and I've seen a lot of consistency in the business. And I want to welcome you here. We have a Q&A box, or there's supposed to be one. If you want to pose questions while we go, or which probably is easier, you can send me an email after the presentation with any questions you may have. Be happy to answer them. And when this is over, we will be sending probably tomorrow a copy of the slides to everyone who attended. And that you will have them to look at. And again, if you have questions, you can just email me. Now, I see we're at 8:30. So why don't I just begin and welcome you all. Hope you find it interesting and enlightening. The webinar is about a unified patent eligibility theory. And one of the reasons for having a unified theory is to provide a method for deciding if a claim is directed to patent eligible subject matter or not. One of the problems that we have is that the Federal Circuit has its own way of doing things. It has not provided us with any overall arching philosophy of how you determine patent eligibility. And the Patent Office, although it's issued what it calls guidance, hasn't either, since the guidance when it comes to determining patent eligibility uses examples rather than trying to provide a general method that you can use with any claim to determine eligibility. Now, you might ask, if the Federal Circuit hasn't done it, how can Dick Kelly do it? Well, the answer is you look to the Supreme Court, and that's what we'll do tonight or this morning. And the key point to remember throughout this entire thing, that it's the claim that must be directed to the patent eligible subject matter. In the words of the late Judge Rich, the claim is the name of the game. When the quantum case came out, many people were complaining, oh, this was a breakthrough invention, which it was. How can it not be patent eligible? While the court didn't find the invention not patent eligible, it found the claims not patent eligible. And that's something to remember. If you don't get your invention into the claim, you may very well find it to be patent ineligible. Now, this is the first thing you have to remember. Indeed, if you go back and you look at sequentum, and we will, in the very first column of the patent, they described what the invention wasn't. And unfortunately, that's what they claimed. Now, one of the problems that we have is, although we have the Patent Office giving us guidance, the USPTO guidance is not law. It's not followed by the courts. Guidance is very different from a rule. When an agency issues guidance, it binds the issuing agency only. That is, when the Patent Office puts out guidance as to what it will do or not do, it's bound by the guidance, not the people before it, not the applicants. Furthermore, because it's guidance, it's not applicable to the public or the courts. Whereas a rule is applicable to everyone And it's entitled to what we call the Chevron deference. That is, unless the rule clearly contravenes the statute, the agency's interpretation of the statute is given great weight by the court. Here, none. Now, one of the things that's important is why is patent eligibility such a big issue? Well, patent eligibility is a question of law. And as a question of law, there's a couple of things that flow from that. It means first that there's no presumption of validity. So the accused infringer doesn't have to meet the burden of clear and convincing evidence. What he has to do is persuade the trier, persuade the court as to the legal question. The presumption applies to factual disputes, not legal ones. The other factor here is that because it's a question of law, there's no need for a trial. There's no need for expensive discovery. In fact, what defendants often do is simply file what we call a 12b6 motion. You don't have a cause of action because the claim's not patent eligible. This is a comparatively quick and cheap way to end litigation if you're the defendant and accused infringer. Now, we need methodology if we're going to be able to obtain patents which are patent eligible. And patent eligible means claims that the patent office will issue, claims that the Federal Circuit will enforce, claims that others will respect. If you're in the licensing business, claims that people will want to license. So we need to have a prosecution strategy that allows us to navigate, on one hand, the PTO guidance, and on the other hand, Federal Circuit decisions. On providing advice to clients, we need to have a basis for our opinions regarding patent eligibility. You can't rely on the Patent Office guidance and the examples because they're not binding on anyone. Second, whatever advice you're going to give, we need to recognize that the issue cuts across all technologies. There's no difference in how you go about this, whether it's electrical, mechanical, chemical, diagnostics, systems, whatever it is, the methodology is the same because the problem is the same in all of them. And one of the things that we have to recognize is that we cannot come up with a methodology unless you know the source of the patent eligibility issue. Now, one of the things, the one thing that we can say for sure is that the source is not the Supreme Court. The Supreme Court has been handing down decisions since the mid-19th century in this area, and they have been remarkably consistent for the last 170 years. Indeed, the 1850 Morse case is cited to this day by the Supreme Court for its proposition of patent eligibility. Now, the Federal Circuit is a problem because it doesn't follow its own precedent. If you compare the Association for Molecular Pathology, which is better known as the Myriad case, the Federal Circuit on a 2-to-1 decision decided isolated DNA exists in a distinctive form and therefore is patent eligible. They ignored the earlier Marden case, which was en banc from the CCPA, which held that purified uranium and vanadium were not patent eligible, even though they were more ductile in the natural form. The Federal Circuit simply ignored it. And the CCPA decisions are all binding on the Federal Circuit. That was one of the first decisions the Federal Circuit made. Unfortunately, the Federal Circuit has a bad habit of not applying stare decisis and going out and deciding each case anew without looking to the past. Now, we don't have uniform guidance from the Federal Circuit at all. They have not adopted a test or a protocol to apply whether their claim is patent eligible or not. And that has been complained about by the district court judges, with Judge Albright putting his complaint into writing in his decision in Health Discovery. He took 3 Federal Circuit decisions, lined them up, and said he couldn't rationalize the 3 of them. They were all over the place. So this is the problem with the Federal Circuit. Federal Circuit has a tendency to decide that patents are fact-intensive and to not create any general rules. Their right is to be fact-intensive. But when you're doing something that's a question of law, it's not so fact-intensive. You should be able to do the job. Another example of not following its own precedents is the Macro case. This is a patent eligibility case which went to the Federal Circuit twice. The first time, the judge had decided that the claims were to a patent ineligible subject matter. And Macro had claims were a method of synchronizing the voices of a cartoon characters to the dialogue. And the claims didn't have any specific ways of doing it. It was all result-oriented. Federal Circuit reversed because they said, wait a minute, in the specification, they have a specific method of doing this, not in the claim. So I went back to the district court. The district court had it for summary judgment because the claim was much broader than the written description and specification. The specification had one method, one way of doing this. Well, it goes back to the Federal Circuit. Federal Circuit reverses. And in reversing, what they did is they did a claim construction and read the embodiments in the specification into the claims. If you or I did that and argued, we'd be hit over the head with the gavel. Now, in this particular case, there was no harm because none of the accused infringers used the method that was in the patent. They had all developed different techniques. But the failure to be consistent is really a problem for us and for the district court judges. Now, the other source of problems is the Patent Office itself. One of the problems that we face is the Patent Office doesn't do a very good job of applying the substantive patent law statutes, in particular 102 and 112A. Virtually every case that has been determined to be patent ineligible also had problems either with prior art or with lack of an enabling disclosure. The Ariosa case versus Sequantum, and we call it Sequantum, had claims that were broader than the enabling disclosure. When you read the first column, you recognize what you found was that these very steps that were in the claim, and the only steps, were disclosed to be not work. You couldn't practice the invention with the prior art sequencing of steps. Now, Sequantum was directed towards finding in a blood sample, a mother's blood sample, the fetal DNA in the fetus. It's a great invention. But Sequantum, the claim that they were going up as a representative claim, didn't tell you how to do it. Should have been rejected for lack of an enabling disclosure. Obviousness or anticipation, well, the Mayo case is a great one for that. This was a case where the doctors, which was directed to a therapeutic window for a drug, and the therapeutic window was defined by the concentration of the drug's metabolite in the patient's bloodstream. The problem was that doctors for years had been looking to see if they had the proper dosing by analyzing for the amount of metabolite in the patient's bloodstream. The only difference was the claim now put a lower and upper limit on that therapeutic window. But the steps for getting to that are all the same. In effect, what they did is made the prior art method that the doctors used into infringement. There was no difference. It was inherently anticipated. Patent examiner missed it. Now, the third bad actor, well, I guess we can all look in the mirror, it's patent attorneys. Cruel when you become a patent attorney is they tell you to make your claims broad so nobody can design around it. Now, like the English language, which has a lot of general rules, we all know they have every general rule in English has an exception. This general rule has an exception as well. If the claims are reciting one of the judicial exceptions, then if you make the claim so broad that nobody can design around it, you have in effect preempted the natural law that's involved. So you've got to be very careful that when you're dealing with one of the judicial exceptions, whether it's natural law, product of nature, or abstract idea, that you don't make it so broad that nobody can design around you. Because at that point, what you've done is you've preempted that judicial exception. Now, the problem is most of us forget history. In the United States, we're a common law country. Common law is a wonderful thing. It allows the law to change as things change. You know, we talk about, you read the 102 statute, we talk about printed publications. Well, when the first patent statute went out, printed publications were simple. They were printed on the Gutenberg press. Today, printed publications takes in all methods of transmitting and sharing information. So what people forget is that part of the history of the patent law is that the original patent statute, the statute of monopolies in England in the early 1600s, was adopted because the kings and queens of England liked to sell patents to people for money. They'd have money to be kings and queens. They couldn't raise taxes because that was in the hands of Parliament. So they issue a patent for money and give somebody a monopoly to sell a product in a particular area. The only problem was the product they were giving the monopoly to sell on was already in the public domain. Now, when they did this with salt, that sort of broke the camel's back, and Parliament acted and passed the statute of monopolies, which required that the thing be new. The key point here is that what the kings and queens were doing when they were removing from the public something that had previously been in the public domain. And if you think about it, a natural law or naturally occurring substances are in the public domain. Whether they're recognized is not important, but they are in the public domain to be used freely. Abstract ideas, well, it's just an idea. It's not an invention. It's not anything that's specific. And that too is in the public's ability. So the very first statute was dealing with this. Now, what the Supreme Court has done is they have said very clearly that patent law must not inhibit further discovery by monopolizing natural laws. Now, I put in brackets there preempting. To me, the word monopolizing has a bad connotation in the United States. Back between the 1920s, and probably the late 1970s, early 80s, patents were considered monopolies, monopolies were considered bad, so patents were considered bad. So I sort of like to use the word preempting. And this is what the Supreme Court talks about. Now, this was in our friend Mayo. And what they said in Mayo was what basically the patent was doing was converting something that doctors had been freely doing before the patent into an act of infringement. And the Supreme Court relied on the 1854 O'Reilly v. Morse case. In that case, Morse was patenting a telegraph. But he had one claim, Claim 8, which simply recited sending symbols over a distance using electromagnetism. And the Supreme Court said there were two problems with this. One, you were preempting the use of the natural law of electromagnetism. And second, you didn't enable it. Now, preemption can arise if your patent protects the only commercially viable way of detecting a natural phenomenon. And that carries a substantial risk of preempting all practical uses of it, which is one of the concerns that the district court judge had in Sequantum. Now, I don't know that that necessarily is correct, but clearly in Sequantum what was happening is the claims preempted anybody from using the CFF DNA because they were claiming the only way of getting it. So the fetal DNA was being monopolized because of the way the claim for finding it and separating it and recovering it was so broad. Now, the Manual of Patent Examining Procedure, interestingly enough, recognizes that preemption is the court's concern. The problem with it is that the MPEP looked at preemption per se. They didn't look at it in the context of the claim invention, which is the second step analysis. So what the Patent Office in its guidance does is in the manual, it sets up a routine for the examiner to follow, which is generally pretty good. It tells the examiner first decide if the claim does recite a judicial exception, and then second, look to see if the claim has something that makes it more than that. The problem is that the Patent Office, in trying to tell the examiners what the more than that is, uses something on the order of, they have 60 somewhat specific examples, 46, excuse me, specific examples, but they have many subparts. So they get about 200 examples, and they don't bother to try and provide you with a single methodology for doing it. Now, it's important to note that preemption doesn't mean preemption of all uses of the judicial exception. It's all uses in the field of the claim. In Sequantum, the field of the claim was the recovery of the fetal DNA. So what you look to see is, was the claim preempting that use? Now, the preemption methodology will tell us the claims are patent ineligible if the scope preempts the judicial exception. In other words, no way to design around it. If it's a truly abstract idea, there's no way to design around it without infringing it. Because the abstract idea doesn't have any specific methods or steps for carrying it out. It's like science fiction. Now, the key here is the preemption is in all of the patent ineligibility cases, although most often it's not articulated by the courts, including the Federal Circuit. The district courts are trying to wrestle with the fact that they've got to try to work through Federal Circuit decisions to figure out what they're supposed to do and hope they get it right. Now, we do have a conflict between the Patent Office and the Federal Circuit. The Federal Circuit has specifically decided that they will not follow or pay attention to the Patent Office guidance. Just as Judge Brinkema from the Eastern District told Cleveland Clinic and Cleveland Clinic 2, the Patent Office guidance is not entitled to any deference. So the Federal Circuit has said the same thing. So what we want to do is we want to say, well, how should we do this? We have to use the Patent Office guidance because that's what the examiners expect. But we also want to make a record that will help us if this case goes on appeal to the Federal Circuit, either directly from this Patent Office or by way of litigation and appeal. And we want to help the judge when he looks at the record to see that the Patent Office did its job right. Well, what the PTAB does when they decide 101 cases, most often what they do is they will first apply Supreme Court law, sometimes with the Federal Circuit, to decide if it's patent eligible. And then they will look at the PTO guidance to see where it falls in there. And they'll always find, if they find it patent eligible under the Supreme Court standards, it's patent eligible under the PTO guidance. And they'll find an example that makes it look that way. Sometimes they'll flip it. They'll look at the PTO guidance, and then they'll look at the case law. But those decisions are never grounded solely in the PTO guidance. They're always looking to make sure that they apply both Federal Circuit, Supreme Court law, and the Patent Office guidance. Now, what I want to do is basically test the concept of preemption by applying it to a diverse group of cases. Some are mechanical, some are chemical, life science, and some are system cases. Now, I want to start with two, and they are American Axle and Sequinum. And these two cases really provide a lot of information on what one should do, both in drafting patents, but also in litigating them. Now, in American Axle and Sequinum, it's important to look at the claims that were pursued by patent counsel in each. In both cases, patent counsel presented a very broad claim. Too broad, actually. But they also presented narrow claims, so that you had claims of varying scope. And so that was the first thing these have in common. That meant that they had multiple bites at the apple, if you will, for patent eligibility. They presented the broad claim, but if that didn't work, they had a narrower claim that was calculated to be limited to what the invention was. Now, you also, at the Sequinum case, learn about the danger of using representative claims in district court and the Federal Circuit. For reasons which aren't clear from the record, litigation counsel for Sequinum picked a single representative claim. He ignored the narrower claims that had been presented to the Patent Office by patent counsel. And we'll see what happens later. Well, first, let's look at American Axle. This is the preamble to the claim. And basically what American Axle was dealing with was a drive shaft in a car or a light truck. And what they wanted to do, everybody wanted to do, was to get the weight out, make it thin and light for fuel economy. Well, one of the things with drive shafts is they're going to be subjected to a lot of forces, some radial, some longitudinal, and those will cause vibrations. And so what he wanted to do was to put together a driveline which was as light as possible, but which didn't have problems with vibration. Now in Claim 22, which is the broadest claim, just goes through, it says you provide a hollow shaft member. Well, That's not a scintillating limitation. It says you're tuning a mass and stiffness of at least one liner. Doesn't tell you how you tune it or what the stiffness should be. Inserting the liner into the shaft member doesn't tell you where to put it. And then say the liner is tuned, resistive absorber for attenuating shell mode vibrations, and bending mode vibrations. We're not told how that's done. Now, it just so happens that there's a law called Hooke's law, which deals with vibrations and explains what you're supposed to do. Here, what you have is a claim that basically tells you what the result should be, but doesn't tell you what the structure is. Now, in the 19th century, it had been well established that one patents the invention and not what the invention does. This was a claim on what the invention does, and was found to be patent ineligible because it was nothing more than a Hooke's law. Now, claim 1 is interesting. First off, it's a narrower claim. But what it does is it requires that one position the liner such that it dampens the vibrations. You're going to say, well, that's not much more than what's in the first claim, claim 22. Well, the reality is that the positioning is something that you would have to do a claim construction on to find out what that term meant. Did the patentee actually explain what positioning meant? Because the job of the patent claim is not to enable itself, but simply to provide an identification of what you're claiming. It's the job of the specification to enable the invention. And what the court said is, we cannot say that claim 1 is patent ineligible because you have to go through and you have to interpret this claim in light of what's in the specification. Now, what's key here is that they looked at claims 1 and 22 separately because they were presented separately. They took claim 22 to be Hooke's law, preemption because all limitations, all uses of Hooke's law, common to all uses in Hooke's law in a hollow drive shaft, and it preempted the use of the law. But when you went to claim 1, the court said, look, it adds some limitations. Tuning the liner to attenuate at least 2 types of vibration, and positioning the liner. Court decided that they needed claim construction to see whether or not the claim was limited to Hooke's law and nothing more, or if these limitations provided more than simply the law. In other words, could one design around claim 1? The answer would be how the positioning was described in the specification and how it would be interpreted. But the key here was the litigation counsel did not pick a single claim for to be exemplary. Both claims were used. And because of that, American Axle lived to fight another day. And we'll see how that comes out. Now, again, here, preemption using the natural law without specific structures to implement. You've got preemption. Claim 22 lacks specific structures. Claim 1 maybe has specific structures once it's interpreted. Now, the key here, and you want to take this away when you're doing prosecution, is you want claims of different scope. When you're litigating, you want to argue them separately. Now, a lot of times the courts don't want to interpret 20-odd claims, but you certainly can find claims of different scope. And the court's going to let you have 2 or 3 claims, maybe 4, if you can show them that they're different in scope. Now here claim 1 survived, and maybe they can salvage this thing in claim construction. Now sequenum is interesting. What happened was in litigation, they picked claim 1 as representative of all the claims in litigation. Now, the Federal Circuit, in its opinion, noted specifically that claim 24 appeared to be different. Oh, and it was very different. But the court said, since you've picked claim 1 as representative of all of them, we're not going to consider claim 24. Big mistake. Now, what Sequenum's attorneys argued in the district court and at the Federal Circuit was that their invention was finding the source of the problem. Well, if that's the invention, you'd expect to see it in the representative claim. Well, here's claim 1 and claim 24. The first thing that you will notice is that claim 1 is shorter than 24. It has fewer limitations. And when we highlight the differences, claim 24 talks about removing substantially all nucleated and anucleated submaterials from the blood sample, and then performing the amplification on the remaining fluid. Those steps tell you where to find the paternally inherited nucleic acid. When you're analyzing a blood sample, you typically spin it down in a centrifuge and it'll separate. And depending on how you do it, you may get 2 or more fractions. And what this claim is telling you, you want the fraction which is substantially free of cell populations. And that's where you want to look. Claim 1 doesn't have that. Claim 1 doesn't have the invention in it. If you claim 1 was what the prior art had used to try unsuccessfully to find the CFF DNA, the paternally inherited nucleic acid. So you want to make sure that if you're going to have a representative claim, that you have your invention in there. And claim 24 doesn't preempt the CFF DNA, the paternal DNA, because the removing step allows for possible design around. And that's terribly important. Now, by selecting claim 1 as the sole exemplary claim, litigation counsel nullified the prosecution counsel's presentation of claims of varying scope. You want to be very careful. And what was surprising to me is just in column 1, the quantum patent, it told you that those steps in claim 1 didn't work, didn't give you the result. So litigation counsel got greedy, and their argument fell on its face because it wasn't in the claim. Where was the instruction as to where to look? It wasn't there. So you want to be very careful to make sure that you have claims of varying scope. If you want to follow the general rule to try and get a broad claim, there's nothing wrong with that. But make sure when you're talking about judicial exceptions that you have claims that are clearly using the judicial exception and not claiming it. Now, this is an example, Athena Diagnostics, of a claim that's claiming a natural law. And this is the claim. It's diagnosing a neurotransmission or developmental disorders. It's akathisia myogravis is the disease they were looking for. And what it tells you is you detect in the body fluid antibodies to this particular kinase. And if they're there, you've got the disease. The problem with that is that the presence of the antibodies is a natural law. If the patient's got the disease and it's related to that kinase, the autoantibodies are going to be there. So what you are claiming is the natural law, plain and simple. You got to be careful about that. Now, what the problem was is that's not the invention the inventors had in diagnostics. If you read the patent, what the problem was that there was a standard way of diagnosing this, and it's in here. You normally tested for an antibody against acetylcholine receptors. And if the patient had that antibody, you knew that he had the myasthenia gravis. The problem was, what doctors were finding is that about 20% of the people that had myasthenia gravis did not have the antibody against the acetylcholine receptor. So this meant that people who had it, but were testing negative, would often not get treated immediately until the physical symptoms became such that the doctor could say pretty much for sure that that's what you had. And what the inventor here discovered was if the patient is negative to the acetylcholine receptor, but has symptoms of myasthenia gravis, what you want to do is look in that patient's blood for the presence of musk. You want to detect it. And if you do, he's got the myasthenia gravis. And if you don't, he doesn't have it. So it was a two-step process. Two-step process is not a natural law. The claim I've proposed here is very narrow, very simple, and lots of ways to draft this. Now somebody's going to say, "Oh, wait a second, isn't my claim avoidable?" Probably not, because the only use a test for detecting the musk, the kinase, is as part of the diagnosis of myasthenia gravis. No one is going to use that without having first tested the acetylcholine receptor, because the test for presence of musk will give an 80% negative failure. In other words, 80% of the patients who have it will test negative. So what looks like a narrow claim in reality is a reasonably broad claim. Now, collective tech is an abstract idea, and it's a peer-to-peer network. And this is one where the Federal Circuit did find patent eligibility. And this is a claim, and I don't want you to try to read it because you will definitely lose your eyesight or at least get a headache. So what I've done is the defendant here has argued this was an abstract idea. And this is the claim where I've highlighted the parts that are very important. Abstract ideas do not have specific means for doing things or a specific sequence of steps. They're just the idea, much like Jules Verne idea in 20,000 Leagues Under the Sea for this endless power, or from the Earth to the Moon, shooting a projectile into space. Here, what you have is you have some specific limitations. You're going to have a peer-to-peer network. You're going to have a multiplicity of peer nodes. And then you've got to have those peer nodes distributed outside controlled networks or content distribution networks. They're included in at least one communication network. These are specific limitations that have to be met. They are not necessarily met by every network. You go down to the red and you'll see that the content segmentation is based on C and address resolution, trace resolution, and the like. And so what you were doing is you've got two specific means for controlling this content sharing that is specific. And somebody can design around this. because you can distribute without using the technique of the claim. You can use it with control networks or content distribution networks. It may not be as efficient, but you can do it. So here, preemption doesn't exist. Patent eligibility exists. Court found that patent eligibility existed, but they didn't talk about preemption or anything else. They went into the specific of the claims only. The specifics of the claims become important in preemption only to see whether or not you can design around the claim. And naturally occurring. The question is, what is naturally occurring? And that's interesting. We have the Myriad case, which is what this is all about. And in Myriad, they claimed a DNA segment. And the DNA segment is chemically different from how it exists in DNA in nature. When you have a DNA segment, you've only got a portion of the DNA. It's basically cut out of the DNA, and its ends are terminated. And when they're terminated, that terminated segment doesn't exist in nature. So the question was, is it naturally occurring? Well, first thing, the segment contains the same sequence as the naturally occurring DNA. So it looks like it might be naturally occurring. And the key for the Supreme Court was that the claims focused on genetic information, not chemical changes. In other words, this wasn't a case where you took your DNA segment and you used it in a vaccine. You relied on the chemical change. Here, all you were doing was relying on it for the information. And what the claims did is they preempted the use of the genetic information. This was the same concern as in sequential. It precluded the use of information, for Myriad. So what you want to look at is what's going on. In this case, Myriad wanted to control the use of the information in DNA segment. That's patent ineligible. Had they used it to create a vaccine or a drug, that would be different, because you would not be preempting the DNA segment itself or its information be freely available, except in the form of a vaccine or a drug. So when we talk about, you'll see examiners say, well, you cannot get a claim to a DNA segment. That's not true. It depends upon what you're doing with that segment. If it's simply for information, the examiner is correct. If it's for some kind of therapeutic use, the examiner is incorrect. Now, what the Supreme Court talks about is claims focus on the genetic information. That's why they found them to be patent ineligible. Federal Circuit had found them to be patent eligible in a 2-to-1 decision. And here's the vaccine comprised of the gene segment, patent eligible, because the gene segment remains free for other uses. You haven't preempted it. And that's the key point. So what are my suggestions for you? Well, one, whether you're drafting claims or evaluating existing claims, look for the presence of a judicial exception. This is step 1 analysis. If it's yes, then you've got to look at the claims. Is it possible to design around? If the answer is yes, then probably no preemption. Does the claim preempt the use of the exception in the field of the claim? If it does, then the claim is probably patent ineligible. If it's directed to or obtaining information, again, information is things that are freely available. It's out there. It's in the DNA, for example, and it's not going to be patent eligible. And that's what I have. I don't see that I have any questions. Now, if anyone has any questions, feel free to email me. Now, we will be sending out, probably tomorrow, the slides for everyone who's attended so that you can look at them. And if after you do that, you have questions, just send me an email and we'll get back to you. And I want to say thank you to all and have a great day.